sort of sorting that out, can I just have a show of hands and answer the following question? If anybody identifies any one of the following three names, put your hand up. William Blake, Cecil or Caesar Wright, John Falconbridge. Okay. Well, to understand the proposition and the question that we're going to be talking about today, those three individuals actually play a significant part. And why are they? William Blake, Caesar Wright, and John Falconbridge are really the founders of the Canadian law school. When we're talking about a law school, we're talking about a law school that was proposed and will now be created by the Trinity Western University, which is a liberal arts college in Langley, BC. We're talking about a law school and the interconnection between the Law Society, which represents the profession. The Law Society is the profession. That's one of the reasons why it's called the Law Society. When you graduate and enter the bar, you will become a member of the Law Society. You will no longer be in law school. Law school is a completely different thing. Law school is a branch of a university which has a completely separate charter and letters patent from the government of Canada or the government of Ontario, whoever is the government entity establishing the school. Now, the first law students were actually not in a university model. It was a trade school model, as if you were studying to be a plumber or a carpenter. The legal profession had its own schools, and the legal profession had the power to confer licenses and law degrees, and it still does. The first university professor who taught law was at King's College, which is now the University of Toronto University College, and William Blake was the first law teacher in Canada. There were no law schools in British Columbia, and there were no law schools in Nova Scotia. There were law schools in Ontario, Upper Canada, and there were law schools in the province of Quebec, teaching civil law. In the 1950s, the Law Society actually discouraged their students from attending academic lectures. They thought that law and academia should have nothing to do with each other. And that point may seem very strange now, but it is a bias on the part of the Law Society that has never been 100% abandoned. However, there were those who thought, well, maybe we should have an organized school for lawyers. And so the Osgoode Hall Law School opened in 1889, about 100 years after the Law Society was created. And the Osgoode Hall Law School's curriculum was controlled by the Law Society. Fast forward about another 50 years, and the Osgoode Hall Law School's principal was a professor by the name of John Falconbridge, and a student by the name of Cecil Wright enrolled in 1923. Why is that significant? Because they would end up sparring against each other as to who should control the legal profession and who should educate the legal profession. Falconbridge was of the school that law is a tough profession, that it involves a lot of hard work, black letter law, and you can only learn law by doing it. Cecil Wright, or Caesar Wright as he became known at the University of Toronto, believed that law should be a more caring profession, that there are nuances within the law, and it should be taught at a university. At that time, to become a lawyer, you had to actually be working in a law chambers under the tutelage of a licensed lawyer and go to law school at the same time, which meant that you went to law school first thing in the morning, and after your 10 hours of work, you go to law school again. Now, Falconbridge and Wright were very important figures in the creation of the modern law school in Canada. Falconbridge went to the Bar Association, which was the Canadian Bar Association in Ontario. And then one of the things that Falconbridge was concerned about was that they were letting in too many students, too many potential lawyers. So he asked the Law Society to, or had the CBA ask the Law Society to require a 2-year pre-law school undergrad requirement. And if anybody wondered why you had to go to undergrad for at least 2 years, and now most people do a full degree, this is the origin of it. There was still a belief that this is, the idea of having a university teach law is a crazy thing. Cecil Wright gave a famous speech, a lecture in 1931, and the main theme of it was that taught law is tough law. Taught in the terms of taught on the job. That law is something that you require an education, something to develop within yourself to be able to help others. In return for the speech, primarily, the Law Society was not having any of this, and it abolished the 2-year undergrad prerequisite, and it went back to what it was before. What ensued in the next 20 to 30 years was what was called the fiercest debate in legal education. One of the prominent students of that debate was Borlaskin, who became one of the deans of the University of Toronto Law School and went on to become perhaps the most famous Chief Justice of Canada. Now, if you ever wondered why you have to learn certain things at law school, well, in order to qualify for licensure, it was because there was an agreement. It was a back-of-the-envelope agreement. Quite literally, it was about a page-and-a-half long, and it was called the Arrangement between the Law Society of Upper Canada and the Ontario Law Schools. At this point in time, there was no formal agreement or even a regulatory standard with respect to what a legal education was. It was just this letter between what was then the University of Toronto, which then got signed on through other Ontario law schools, and the Law Society of Upper Canada. It was there that there was a bar admission course that was established, that core curriculums such as contracts, torts, and constitutional law had to be taught, and there was the introduction of formal articling bar exams. Now, the significance of this slide is that this second point, the law school course, the 3 years with a core curriculum, was adopted by the Law Society as a term of licensure, that you had to have this particular degree from a Canadian law school in order to qualify to be a candidate to be a lawyer in the province of Ontario. So this academic degree becomes incorporated as part of the licensing process. The significance of that is that the recognition becomes more than just an academic degree. Law Society doesn't care about other degrees such as LLMs or PhDs or LLBs. It's just this one degree, and it becomes part of the public franchise. Now, the next 40 years or so, nothing really happened. It was this one-page agreement that governed. What happened was the Law Society did its own thing, and the law schools did its own thing, and there was always a suspicion between the two because the law schools thought, oh, we don't want any interference with academic freedom. The Law Society said that, well, we want things to be taught. Enter the TWU issue. Now, TWU, Trinity Western University, is a liberal arts college run by the Evangelical Free Church of Canada, which is a branch of the U.S. Church of that name. And in 2001, there was a case before the Supreme Court involving the College of Teachers of British Columbia. And it had to deal with the licensing of teachers who graduated from TWU, who had to, as a condition of being a member of the university, either a student or a faculty member, you had to adhere to this community covenant, which said you must refrain from practices that are biblically condemned. And it included a whole bunch of things, including betting and that sort of stealing. And it included sexual sins, including premarital sex, adultery, homosexual behavior, and viewing of pornography. And there were a bunch of biblical references, and if we have time later on, you can ask me about that because it's quite interesting. But homosexual behavior is one of the criteria that or one of the things that you're not supposed to engage in. And so there was litigation, charter litigation, in which the Trinity Western University won. The Supreme Court held that the College of Teachers had limited jurisdiction to consider discriminatory practices as delegated, but it did say that TWU is not for everybody. The admissions policy of TWU alone is not self-sufficient to establish discrimination under the Section 15 Charter jurisprudence. And this was important because there was no evidence before the court that this admissions policy would lead to discriminatory practices in public schools that TWU lost. So one and the College of Teachers lost that litigation. Well, at the same time that this was going on, the Academy and the Law Society was at its old tricks again, because the Federation of Law Societies, which have been created to establish harmonization of things like mobility in the legal profession, started to say, well, we'd like some standards, because we have all of these students and lawyers from England and Africa and Australia who want to become lawyers here. We have to establish formal criteria. The law societies have to back off, hands off our academic curriculum. So the conflict was resolved perhaps not to the satisfaction of either side, but through the development of a federation of law societies, set of criteria which law schools had to adhere to in order to be accredited. The law deans didn't like it, but they thought that they were having their academic freedom impeded. But the law society said, well, we'll pass this and we'll sort it out later. In 2006, there was the election of the Harper government. Trinity Western University wrapped up various political efforts, including the creation of a Laurentian Leadership Center in Ottawa. It was supposed to be an incubator for evangelical Christian lobbyists. And it also had already some plans to create a law school with the belief that we'd like some Christian lawyers. And it was at this moment, within the legal profession, with its squabble with the Academy, that the Trinity Western University decided, well, if we can satisfy the Federation's criteria, we can get a law school. Now, move forward another 6 years or so, and then TWU actually did amend its covenant. It no longer said you have to agree that homosexual behavior is a condemned behavior. But what it did say was that if you want to come to our school and learn about the law, you have to refrain from sexual intimacy that violates the sacredness of marriage between a man and a woman. Now, this was at the same time, as you may recall, that there was litigation and statutory reform with respect to same-sex marriage in Canada. So there was going to be a little bit of a conflict there, but of the social nature. In 2012, TWU applied formally for Federation of Law Societies approval, and it got it. Because they said we were going to teach contracts, torts, litigation, all those things that you're supposed to learn, we're going to teach the kids. Law Society of Alberta and British Columbia at first said, okay, well, we have no discretion. Federation criteria, that's what it is. So they rubber stamped the approval. Law Society of Alberta Canada and the Barrister Society in Nova Scotia held hearings. BC, and you might have seen this in the newspapers, BC reconsidered its decision, but the benchers said, well, our hands are tied by the 2001 teachers litigation, so we will just rubber stamp the approval, or decline to reconsider the rubber stamp. There was a referendum held in which the profession in BC said, no, we're not having any of this, we'd like you to reconsider. And then the benchers said, well, we're bound by the referendum, so even though we might decide in the same way, we're just going to do what the referendum said. It was an example in administrative terms of the same body coming to two different conclusions and making the wrong decision twice. It's quite remarkable if you follow that. The Law Society of Alberta Canada, now the Law Society of Ontario, held hearings, and I believe that the hearings are still available online. It's quite remarkable from a legal practice perspective because the Trinity Western University had employed one of the finest appellate advocates in Canada, a friend of mine, Eugene Meehan, QC. I think he's argued like 30 or 40 Supreme Court cases. And they hired him to attend the hearings, and they had him sit in the corner while the president of the university made all of the submissions and essentially said that Trinity Western University was the victim. I call it the fake media now, but victim of abuse from the media or liberal thinkers, whatever. And the Law Society didn't really care about all of that. The Law Society's concern was, well, how do we deal with incorporating a law degree into our licensing process, which is what accreditation is, in which the students are required to sign a covenant that discriminates against LGBTQ candidates. My small role in that process was that I submitted a brief in which I said, well, whatever your views about the religion, whatever your views about the equality rights of LGBTQ communities, the Law Society does not have a role in regulating law schools. The Law Society cannot say you cannot have your law school. The Law Society's role is to say we will recognize your degree. And TWU, on the other hand, cannot say that we require you to accredit because the Academy has no say in the affairs of the profession. And that's an important point. When we go into the plenary discussions, maybe we can develop that further. Now, as you all know, the Trinity Western University hearings before the Law Society ended up in very much a patchwork. As I said earlier, there was a rubber stamp in Alberta. There were some provinces in which law societies decided not to do anything. In Nova Scotia, the courts told the Nova Scotia Barristers Society that their decision not to accredit was ultra vires of the statute. And in 2018, and that's still the binding in Nova Scotia, they have to accredit in Nova Scotia. Now, 2018, the Supreme Court of Canada held the Law Society of British Columbia and the Law Society of Ontario, their decisions were withheld, were within their jurisdictions and within their competence to interpret the charter. The temporary result, there is a patchwork, and the final result is that this year, Trinity Western University withdrew the covenant requirement for students. Now, the final thing that I have to say about this is that throughout the deliberations and throughout the debates, I don't think that anybody on the side of the majority or the side of the Law Society's decision ever disputed the right of a Christian university to have a Christian law school. And the only problem was whether the candidates should be required to sign a covenant, which in many cases offended their very personal identities. And it was really on that point. What the history of this saga shows is that Trinity Western has been prepared to amend its covenant, to sanitize it, I call it, from that original condemnation of homosexual behavior to, well, you won't engage in any conduct that defies the sanctity of male-female marriage, to now not having the covenant at all. So the Trinity Western University will, by all accounts, have a Christian law school. The only difference is that in order to be a candidate for admission, you do not have to sign that covenant. So that's sort of the rainbow arch, as it were, of where we are now and where we're.
Thank you, Lee, for those comments, and thank you to Runnymede for hosting us today. It's a great privilege to be back here at Western Law. This is my alma mater and proud alumni here. In fact, I learned constitutional and criminal law in this very room. My name is Derek Ross. I work with Christian Legal Fellowship. We are an organization of lawyers that intervene in religious freedom and constitutional cases to serve as a friend of the court, to speak to some of the broader issues at play. So we were granted leave to intervene in all 7 hearings, and independently of Trinity Western and independently of the law societies was our perspective of speaking to some of the broader constitutional issues. So this morning I just want to share a few reflections based on my involvement as litigation counsel to an intervener in these hearings on why I think that Trinity Western is such a significant case, whatever your views on the outcome. Some reflections on the decision itself and some concerns that I think that it raises. I think it's fair to say, and by virtue of the fact that we're all here, Trinity Western is a case that has generated a lot of interest. In fact, I think it's probably the most talked about and publicized cases in recent memory, and that was evidenced by the sheer number of organizations that intervened in the case. In fact, I believe that it holds the record at the Supreme Court for the number of groups that were granted leave to intervene in the case. There were so many lawyers in the room that the public had to be moved out of the courtroom into the lobby, and all of the lawyers were seated in the public gallery. And those of you who have observed some Supreme Court hearings, you'll know that it's customary at the beginning of the appeal for the Chief Justice to read out the names of all the lawyers who are on record. And usually, you've got a few for the parties and maybe a couple of interveners. At Trinity Western, there were over 50 lawyers that the Chief Justice went through, and we all stand and bow and nod. It took so long that by the time she was done, Chief Justice McLaughlin joked, "And now let's break for lunch." But I think that is indicative of how much debate this has generated in the profession. And as Lee talked about, it generated a lot of discussion in the law societies as well. And I think it's important to note, this gets lost sometimes, just how close some of these votes were. The New Brunswick Law Society voted to accredit Trinity Western by 1 vote. The Nova Scotia Law Society voted not to accredit Trinity Western by 1 vote, 10-9. In Ontario, the bench's vote was, I believe, 28-24. And of course, in British Columbia, the benches originally voted in favor of Trinity Western and then reversed course after pushback from the bar in a referendum of its members. But before the case even reached the Supreme Court, we had 6 decisions heard by a total of 18 judges. And these were very different outcomes. A total of 18 judges heard the cases. 12 of them sided very strongly with Trinity Western, unanimously in British Columbia and Nova Scotia. 6 of them sided very strongly in favor of the Law Society here in Ontario in 2 unanimous decisions. And I can't recall a decision that has, or an issue, a case, that has generated such polar opposite outcomes in decisions that are released almost simultaneously, arising out of the same issues, same subject matter, largely the same statutory provisions, although there were some differences. And then finally, of course, the Supreme Court decided 7-2 in favor of the law societies. So how do we explain this divergence? How can 7 courts reach such polar opposite outcomes when dealing with substantively the same issue? And I had the privilege of participating in varying degrees in all 7 of those cases. And there's a risk in oversimplifying things in answering that question, especially in less than 9 minutes. There were a lot of factors that went into the court's decisions. But respectfully, I think what it largely boiled down to, at least some of the judgments, was a contest between 2 competing philosophies. Competing philosophies about how we ought to, in Canada, accommodate or address disagreement. Not just disagreement on opinions or preferences, but how do we accommodate disagreements on issues of fundamental importance to the respective parties? Issues that are deeply cherished, even central to their sense of identity and worth on both sides. So what were these 2 philosophies that prevailed in the cases? The first philosophy, I think, is what's reflected in the majority decision of the Supreme Court in Trinity Western. And that philosophy says we do need to accommodate difference in a free and democratic society, but there are limits to what we will accommodate. And we will only accommodate differences to the extent that they do not conflict with what the majority describes as fundamental shared values. The values of equality and human rights were ones that they listed. Those are values that the majority says that the state always has an interest in promoting and protecting. I think that is the underlying philosophy that you see in those decisions that decided in favor of Trinity Western. Other than the Nova Scotia Court of Appeal decision, which is strictly an administrative law decision. The second philosophy is, I think, best reflected in the dissent's decision in Trinity Western, the Supreme Court, that says this: in a free and democratic society, we will inevitably have fundamental disagreements. People will hold conflicting moral values. And it is not for the state to try to reconcile those conflicting moral values into one universally accepted conception of how people should live their lives. That there is wisdom to the idea that the public sphere is for all to share, even where beliefs fundamentally differ. So their approach is, and the dissent was actually quite strong in disagreeing with the majority, their approach says the limit on what we will accommodate shouldn't depend on quote-unquote shared values, but on the state's enforcement of minimal core civil commitments which are necessary to secure civic order. In other words, what do we need to ensure that we can still peacefully coexist in respect, but not necessarily in universal agreement? Outside of that, the public interest is served by promoting the accommodation of difference. So that latter philosophy is what prevailed in the cases where the court decided in favor of Trinity Western. And that, I would suggest, has been the traditional test in Canadian jurisprudence. We all know in constitutional law, no charter right, no charter freedom is absolute. That includes religious freedom, it includes equality. But ever since Big M, the court has said that state actors must accommodate religious freedom to the extent that they don't interfere with the rights and freedoms of others. That seems to have been stretched by the majority in Trinity Western, where they've said the test is no longer just the rights and freedoms of others, but to the extent that disagreements conform to shared values, also described throughout the decision as charter values, as opposed to charter rights. So this raises some concerns in my respectful view. And again, I'm sure there's disagreement even in the room in terms of the outcome, and whether you agree with the outcome or not, I'd encourage you just to reflect on a few things. One is, does this approach, does this reasoning really accommodate and facilitate diversity? Or does it simply replace one orthodoxy that we find objectionable with another new orthodoxy? Another new moral orthodoxy where we say, you must affirm and celebrate this conception, or else you will not be entitled to equal access to public programs in the public square. In other words, our charter values our new civil religion. And if so, who decides what charter values are? Right? They aren't written in the Constitution. They aren't the settlement of constitutional doctrine. And why should values, which are not written in the Constitution, trump charter rights, which are? And you see that tension in the decision. Right? It was 7-2 in favor of Trinity Western, but if you've read the case, the split was much narrower on the question of charter values and whether it's an appropriate mechanism to decide these decisions. So how did we get to the outcome? The dissent, and I agree with the dissent, respectfully, that we didn't get there through a strict application of existing law. Some would say, well, no, this is just like an ordinary case. Trinity Western can't exercise its rights in a way that violate the rights of others. But remember, the court never found that Trinity Western violated anybody's rights. In fact, there is no applicable human rights law that prohibits what Trinity Western wanted to do. The applicable human rights provisions actually contain exemptions for religious organizations to have these types of codes of conduct. And it did not violate the charter. The charter doesn't apply to Trinity Western because Trinity Western is not a government body, it is a private actor. And there's also no dispute, in fact in some cases the law societies even conceded, that Trinity Western graduates would be competent, qualified, and ethical lawyers. So legally speaking, Trinity Western acted fully within the law, but the court concluded even though the charter doesn't apply directly, its values are so important that they will apply indirectly, and therefore help determine the outcome of the dispute. So the question I have is, are we comfortable with that? Outcome aside, are we comfortable with this idea of values talk being what determines the outcome of legal disputes, even overriding charter rights? Does this type of analysis give too much leeway to decision makers to simply give priority to their moral judgments and use charter values as a rhetorical device to say, here's why my conception of equality ought to apply in this case? Obviously, equality is an important social good in our jurisprudence, a core social good. But we have to be clear about what equality actually means and what it requires. And when we just invoke it boldly as a value, without any discussion of how it applies in this case, it can become problematic. But even more broadly than that, we might be comfortable with this approach now, but a future decision maker might invoke different values to accomplish their outcomes, which we find problematic. Would we be comfortable with a decision maker invoking the shared value of democracy, for example, to uphold bans on religious symbols being worn by religious minorities, some of the developments we're seeing in Canada? What about a decision maker invoking a value of national security to support anti-immigration policies? When we frame everything through the lens of values, it's very difficult to avoid results-oriented reasoning. And finally, I'll say this. The analysis also seems to ignore the fact that freedom of religion, religious association, and equality on the basis of religion are also charter rights, and therefore values underlying the charter. Yet, the analysis seemed to be premised on an assumption that these things are weighed against the charter, that somehow these charter rights are in competition and in tension with the charter rather than consistent with it. And I think it's unreasonable to suggest, as a starting point, that lawful exercises of charter rights, whether we agree with the way they're being exercised or not, are inherently in tension with the public good. So we'll leave it there and we'll save some time for questions. Thank you.
I'd like to focus on the Supreme Court decision itself. Derek was talking about it just now. I have some similar things to say. Let me start with this, though. My own perspective is this. I'm not a Christian lawyer. I'm not a religious guy. Trinity Western would not be a place for me. I would not be the kind of person to sign that covenant. It doesn't represent what I believe. And that is entirely beside the point. In the Supreme Court decision, the Constitution is no longer just a living tree. It is now a unicorn. It is completely made up. What the Supreme Court did in Trinity Western is not in any way reflected by the actual text of the document. Yes, there are debates about what we should do as a society and what values we should have and so on and so forth. Those are all social debates. Debates that the Supreme Court took upon itself to decide for us without the constitutional mandate to do so. I want to give you some examples of the respect with which the Supreme Court has done things that they are not authorized to do. The mistakes that they made, the misrepresentations of what the Constitution says and what it means. So, first, the idea that the case is based upon the balancing of conflicting charter protections. Derek pointed out, the charter in this case applies only to the law societies. The charter does not apply to Trinity Western. It does not apply at all. And of course, also, it is not subject, the school is not subject to the BC Human Rights Act. It is not subject to the Act. Therefore, there is no one who has rights against Trinity Western. Gay people do not have constitutional rights that can be enforced against Trinity Western. They do not exist. So what's being balanced? Balancing of conflicting charter protections. Well, charter protections is a sneaky term because it means charter rights and charter values. So let's talk about charter values. Question: what the hell are those? Where did they come from? The charter is a text that describes rights and freedoms. If you look very carefully, you will find nowhere any reference to charter values. This is one thing the Supreme Court has made up in its imagination that has enabled it to put aside an actual charter right in the text and say that that right is not as important as this other idea that we have, which is the idea of a value. And not only is the existence of charter rights something that's made up, but its content is also highly selective. So let's ask this question. What are the values of the charter? Well, you'd think, if such a thing exists, that the values of the charter should reflect the rights and freedoms that are in there, that are actually in the text. Well, one of the freedoms that is in the text is a fundamental freedom of religion. Is the value of religious freedom a value of the charter? Apparently, no. No, why? Because the Supreme Court doesn't want it to be. Instead, charter values consist of other things the court wants to value more. Things that are not even in the charter at all. Diversity, a particular version of diversity. Equality, a particular version of equality. Note this, Section 15 does not apply to this case. Not at all. There is nobody involved in the suit who is claiming a right under Section 15. And if you look at the wording of Section 15, A and B, it has no application to this case. So here's what we have. We have one party with a constitutional right, the right of religious freedom. And we have another party that is the government, an agency of the government, with a statutory mandate. And so the question only is this: does that charter right, which the court acknowledges has been infringed, is the government agency allowed to infringe it based upon Section 1? And Section 1 requires, as you all very well know, a reasonable limit prescribed by law. So here's the prescription by law. Public interest. That's all. Public interest. A government agency with a mandate to act in the public interest, which the court holds is significant enough, important enough, to override a clear infringement of religious freedom. Nonsense. Why? Because that public interest, as articulated by the law societies, consists of these charter values, which, as I've said, are all made up. What's public interest supposed to mean? The law societies have a mandate to act in the public interest. Doesn't that mean they can do anything they want? Really? Anything they want? Public interest in the statute is supposed to be a signal that this self-governance of the profession is to be done in the public interest as opposed to the interest of the profession. You have two conflicting interests, the profession and the public, and it is the public that the law society is supposed to serve. That doesn't give them a mandate to do whatever they want, and certainly not where you're infringing a charter right. So what do we end up with? We now have the charter acting as a sword against a private entity. Trinity Western was the one that was held here to the content of the charter as made up by those charter values. They were the ones, the court says, who have not adhered to their responsibilities. Well, they have no responsibilities with respect to the charter, or for that matter, with respect to the human rights act. None. This is a group of private people gathered together in a religious context who have decided amongst themselves the code by which they're going to live. Their association is voluntary. You don't have to go to law school, you don't have to sign the covenant. And the Supreme Court has said, you're not allowed to do that. You're not allowed to do that in the context of your religious community unless you adhere to the values that we think are appropriate. That is nothing more than the rejection of the idea of religious freedom. So here's an analogous case. Imagine a mosque. And the mosque decides that they have a number of young men who are interested in the trades, but they're not getting access to the trades. So they set up an apprenticeship program to try and connect those young men with people who are actually practicing in the trades, electricians and so on. It's a successful program. And you get men of the mosque coming out of these apprenticeship programs and applying to the provincial body for licensing to be an electrician. And the licensing body says, you know, you're well trained, you know your stuff, you behave ethically, there is nothing wrong with your background, you are competent to be an electrician, but sorry, no. Because your apprenticeship program was arranged by your mosque. And the mosque program is available only to people who belong to the mosque and therefore only to Muslims. So sorry, that discriminates. And so you can't do that. We're not going to allow you to practice as an electrician. That is exactly the decision the Law Society has made. The Law Society has made no complaint that the students to graduate from Trinity Western wouldn't be competent, well-trained, ethical, and all of the above. The public would be protected, but only on the basis of the admission policy and the admission requirement to sign the covenant in exactly the same way that there would be an admission requirement to the apprenticeship program at the mosque. So, I suggest to you that rejecting the electrician's application for licensing in that situation would be a clear violation of their charter rights. And if it is, then it must also be a violation of Trinity Western and its students to get approval by the Law Society. The Law Society does not have a mandate to pass philosophical judgment on religious values. But that, in effect, is the power it has been given. I'll leave it there. Let's chat.
So at this point, we would like to have a discussion between the panelists. And afterwards, we're going to have 15 minutes set aside for questions and answers. Thank you.
Victor, do you want to open up the floor for questions right off the bat, or do you want us to talk first?
I thought that you guys would go through any comments that you had on each other's presentations. Okay, it's absolutely it's up to you. I'm winging it here.
Okay, all right. Okay, good. What do you want to do?
Maybe I can start.
Sure.
Okay. I have one comment. I don't disagree with any of the comments of my colleagues. Although perhaps the points I think. One important thought following from Bruce's comment, who was the party who was transferred? A fellow by the name of Braden, and I'm going to mangle the name, so I'm going to say Volkanot, who I believe was a young undergraduate at Trinity Western, who said, I would like to, when I graduate, I would like to go to Trinity Western University Law School because I believe in the Christian values of my school generally, and I believe I would be an ethical lawyer, a well-trained lawyer, and provide services to my community. And so Braden Volkner was a live person who was the litigant in the matter before the Supreme Court, whose rights were affected. And there was, you're correct, there was nobody on the other side who was saying, well, I too am an undergraduate of Ontario's Western University, and I would like to go. I couldn't get into Western University Law School, but maybe I can get into Trinity Western University Law School. I'd like to apply, but I don't want to sign that. But there was no such litigant. There was no such litigant saying, I'm advancing my quality of rights. In that respect, Trinity Western University, apart from certain situations, my colleagues are correct, not subject to the BC Human Rights Code, and apart from certain situations, not subject to the charter. Because it is a private foundation. It does receive some public funding, and that's part of the debate. I don't really want to muddy the waters with that. There was nobody saying that the Law Society was telling the university, no, you can't have a law school. And I think that's part of the debate that needs to be clarified. You can have a law school, you can have a plumbing school, you can have an electrician school, you can do whatever the British Columbia Ministry of Education allows you to do. However, if you want, because the Law Society of Upper Canada grants law degrees, and instead of granting law degrees, and that's why Dave went through that whole history of that, the Law Society of Upper Canada used to grant law degrees. But after the agreement with the academies, and we're getting out of the business, we only grant law degrees at the doctorate level to people who have served the law society and the profession for a very long time. And at every call to the bar, there's one person at the ceremony who gets a doctorate. And that's the only law degree. Law Society says, universities, you grant the law degrees, you teach the law. But if you want us to recognize this as a portal for entry into the profession, then it becomes our business. Then we have to decide, is there a criteria that we're employing for entry into the profession that abides by the Human Rights Code, Charter, and at that point, it can no longer just consider the rights of Braden Volkner, but it has to consider the rights of somebody else from this school, for example, at the undergraduate level, who wants to apply, who may be gay, who may be in a same-sex marriage. Because that criterion the Law Society has to apply is, it's not deciding the case of Braden Volkner, it's deciding by accrediting a degree, deciding every single person graduating from that university with that degree is provided an in to the profession. And it was at that point that the Law Society said, well, we have to consider the rights of the unspoken, the people who are on the other side. That's where...
Can I jump in there, though?
Yes.
So, you're right in the sense that there was no litigant who came forward in that position. I agree with that. What I don't agree about is this. If there had been such a person who said, but I want to apply to that school and I can't because the covenant is contrary to my values and therefore it discriminates, the response should have been this. You have no right to that. You can't claim a charter right. The charter does not apply. You can't claim a right under the human rights legislation. That does not apply. What right are you claiming? Where does it come from? Show it to us. Where is the right? There is no such right. Nobody has any legal right to demand to get into the school run by a religious institution. It doesn't exist. There isn't one.
That was not the issue. The issue was whether the Law Society will actually confer So whether that person has the right to become a lawyer.
Yes, yes. Okay, so
As opposed to getting into law school.
let's deal with that point. So the point is, well, they can have their law school. They just can't be approved, and therefore can't be admitted. Okay, well, this is a distinction without a real difference, yes? You can go off and do whatever you want, but the powers of the state to prevent you from engaging in that profession, we're going to deny that to you because we don't like your values. Same thing as with the mosque. Is it appropriate for a mosque to run an apprenticeship program that satisfies all the competence requirements? And for the state agency to say, oh, well, you can have the program, but sorry, you can't be admitted, you can't practice, you can't be part of the society because we don't believe in your values. That is an abuse. That's a violation of the charter right. If you are not preventing people from practicing on competence grounds, then the state has taken over the job of making philosophical decisions for people. And that's exactly the thing the charter rights are there to prevent.
I think that I can't remember what it was called, the electricians. The electrician's example is an interesting one because if it's municipally administered licensing delegated to the if the City of London's licensing department were to hold examinations, and that would be one thing. And then part of the training would be, you can be trained here or you can be trained there. But if it were the City of London said, well, we will grant a license, and a condition of the license is that you receive this training. And we recognize the training by XYZ mosque. And the question there is, do we allow recognition of that as a building block, or do we just not deal with the issue of because it's a delegation. Before the Law Society was doing the training, and it got out of the training business. So unless the City of London wants to get into the training of electricians, to a certain extent it is delegating the quality control for electricians. And so do we recognize the diploma granted by the mosque or not? And in that situation, the City of London would be right to say, well, it is an entry into a profession that is coveted. Electricians do quite well. And so we will require the mosque to open its apprenticeship program to people of other faiths. In the same way that I went to a Christian university for undergrad. I went to Trinity College. And it's actually part of the Anglican Seminary. And I loved it there. I really enjoyed the fact that I was living and learning with people who were also trained to become Anglican ministers. But it was open to me. I don't belong to any faith whatsoever. There were Jewish kids, there were Muslim kids. It did not have a restriction. It did have a covenant. That I actually remember signing that covenant, and the covenant had something to do with I will be honest and protect right to property for some reason. But in answer to the mosque and electrician situation, I would contend that if the mosque wanted to start a law school, then it would have to go through the same process to get accredited as the Trinity Western University. And there would be questions. And there might even be questions that go even deeper than that, as to if there was a history of overt, because all three of the major religions in the world have a problem with homosexuality. And I don't have to get into that. They have a problem with it, and they grapple with it. The Anglican Church is about to split as a result of this issue. If it were a mosque that had a history of discriminating against non-Muslims or against homosexuals in its training programs, then the Law Society, or sorry, whatever the accrediting body, would have as a public entity, would have both the right and the responsibility to ask those questions. Or you're asking us to credit this recognition, degree or diploma or whatever, so that you can enter a publicly regulated profession. Can't we ask those questions? And what the Supreme Court has said is that yes, you can ask those questions. That's my response.
If I may quickly interrupt, because people have to go, I'd like to open up the floor for questions. And just because I've noticed that Professor Pardy and Mr. Akazaki have spoken for quite some time. Mr. Ross, I wanted to ask you, do you see a distinction between a society that homogenously enforces its values and a society that is, pluralistic? Could you speak to that divide? Because I do see that as a fundamental subtext of what Mr. Akazaki is speaking about. And the other thing that I was wondering is that I never hear about the Civil Marriages Act at all, which section 3.1 of that says that no person or organization shall be deprived of any benefit or subject to any obligation or sanction under law by reason of their exercise in respect of marriage between people of the same sex, of their freedom of conscience and religion, or the expression of their beliefs in respect of marriage as a union between a man and a woman. So that's something that never comes up, and it just seems that right there, for all of the other arguments that have been put forward, that right there is an extremely strong argument that I don't often see. So just comments on that, and feel free to ask questions as well.
Sure. So on the first question, difference between what I would call a morally homogenous state and a robustly pluralistic state, yeah, I mean, that's kind of the contest of the two philosophies that I was speaking about. Of all the excerpts from all the decisions, I think the most powerful were the closing words of the British Columbia Court of Appeal, where they said that a society that cannot admit of and accommodate differences in which citizens are free to disagree and to debate and challenge the accepted view without reprisal, is not a free society. And some would say, well, no, come on, that's overstating it. That's a lot of rhetoric. We're still a free society in Canada, and we are. I don't want to overstate the point. But what we're seeing is a trajectory where state actors are saying, these beliefs that we find objectionable, you're free to hold them in the confines of your houses of worship or in the confines of your home, but don't bring them into the public square. And to me, that is not a free democratic society. That is more akin to a society where we don't have freedom. I mean, everyone's free to hold whatever beliefs they want. The question is, do we go the extra mile as a society and allow people to express them within the confines of what is legal or not? The Civil Marriage Act is an interesting one. We did cite that in our factum. So what Victor is referring to is the legislation that actually recognized same-sex marriage in Canada. And its preamble does say that it is not contrary to the public interest for citizens and institutions to hold diverse views on marriage. So that, in our submission to the court, is clear evidence that this isn't contrary to the public interest. This isn't contrary to public policy. The Parliament, the very piece of legislation that expanded same-sex rights, at the same time is saying this does not need to come at the expense of religious communities to hold dissenting beliefs. In fact, that statute also protects the rights of religious officials and religious houses of worship to only host and celebrate and affirm marriages that are in furtherance of their religious beliefs. Technically speaking, though, that's a federal statute. And so it doesn't have any bearing on decisions of provincial bodies or bodies that have provincial delegation of authority, which is what the Law Society was. So a bit of a technical answer to why it wasn't directly germane, but as a matter of principle, I think it was an important reflection of how we got to where we got to, which is to say we can expand equality rights on the basis of sexual orientation, while at the same time not carving away from religious freedom rights. We're not competitors in a zero-sum game, right? these rights can expand while also preserving and protecting these rights. And that, I think, is where the court departed from its wisdom of previous decisions.
Yeah, I was wondering if any of you have any particular thoughts about the administrative aspect of this, because it wasn't the instance that there was part of the Law Society Act which said, oh, you shall not accredit any lawyers coming from an institution that doesn't allow for freedom of sexuality and all that stuff, right? It was the Law Society itself interpreting what was in the public interest, and the courts have said very clearly that you need to give deference to administrative decision makers. So I'm just wondering, does that muddy the waters a bit in terms of like what government action is really taking place here? When really a lot of what the court was doing, I think, is giving deference to the Law Society and what they deemed, and how they interpret their own statute.
So I'll just speak to that briefly, and others can weigh in. You're right, there is some jurisprudence, Green versus the Law Society of Alberta, another recent case, where the Supreme Court has said, when it comes to administrative bodies interpreting their own statutes, and even in the context of interpreting the term the public interest, we will defer to their decisions as long as they're reasonable in terms of what that terminology means. But there's a difference between deferring to the Law Society in interpreting what the public interest means, and then saying the way they've determined it is a reasonable balancing with charter rights. So the question of home statute interpretation is only the first piece of the text. The next piece is, have you now balanced that concept, as you've defined it, proportionately with the charter freedoms? And our submission is a public interest mandate is not a blank check to trump charter rights. And charter rights still need to be understood as consistent with the public interest. So there's still a question of there being a disproportionate balancing. But on that administrative question, that is, I think, where the court landed.
Yeah, I agree with that. It's a way to license a government body with a vague statutory mandate to completely undermine charter rights. I mean, that's what we've got. Because of the tests that are now being applied, they're differential. A body like the Law Society can come to whatever conclusion it wants to that conflicts with charter rights, and the court will say, well, you know, it's fine, they've got the mandate to do that. That's not a charter-friendly approach. But I also think it's cheating. Right? It's cheating in this sense. So if the Law Society, in a different situation, came to a very different conclusion about what public interest meant. Let's say the Law Society said, well, you know, it's in the public interest that we don't have any gay lawyers. And therefore, we're not going to license those lawyers. And we have a public interest mandate. We're allowed to interpret that term, and the court should defer. Well, not a chance, right? Because that interpretation of public interest is not in accordance with the values of the court. And so they say deference, but it's only deference because the Law Society and the court happen to line up about, you know, the values that are appropriate. If you've got a Law Society going off the rails, then, you know, you watch deference evaporate like that.
The Law Society is an interesting administrative law example, because we're used to thinking, especially I did quite a bit of admin law, and we're used to thinking of tribunals, of policy, ministerial policy-making entities, and those kinds of agencies. The Law Society, at the end of the day, if you look at the statute, it continues. It says that the Act does not establish it, it continues. The Law Society, and if you look at the membership, is an entity, a corporate entity that consists of and represents and governs, so those three things, its membership. And its members are all licensed lawyers in the province of Ontario, and it also includes articles students. And so when you're talking about membership, it is really a state monopoly. It is really a group that says, we're the only ones who can advise Mr. Smith or Ms. Jones about the validity of their contract. Nobody else can do it. And we can charge a fee for doing it. If somebody else does that, they will be prosecuted. Somebody without a license does that, they will be prosecuted. So it's really a gatekeeper function that the Law Society, and the Law Society is under scrutiny from the Competition Tribunal at all times. Saying, well, are you there to restrict? Are you a guild saying, if we're only going to have 50,000 lawyers in Ontario, and that's the limit? You can't do that, because that breaches competition law. So we are only going to allow people who have degrees, law degrees. Because it can also admit people into the practice of law who don't have law degrees. And it has done so in the case of people who used to be lawyers in Nigeria, for example. It's called the NCA process.
Isn't that what Suits is about, too? Little Suits joke.
It's a very prestigious, well, it used to be anyway, a prestigious job. I mean, it's different now. But there's all kinds of kids who want to become lawyers, right?
Well, you'll note, though, that if you read the Law Society Act carefully, the mandate of the Law Society is really competence. Do you know what you're doing? Have you had training? Do you behave ethically, or do you steal from your clients' trust funds? It's competence. But you'll note how now the Law Society is moving away from competence into values. The value of the institution, the value of the individual lawyer. I mean, they have, this is the statement of principles problem. They now have a requirement that you fill out your own statement of principles that reflect your endorsement of a certain number of ideas. Okay? That's not competence. Those are values. In my case, administratively, would be the Law Society is now reaching beyond what the statute says to do what it's not supposed to do.
Well, Section 4.1 has 5 criteria, 5 principles that define the duty. The first 4 are public interest duties, and the 5th one is with respect to the admission of students as candidates to the bar and the competence of lawyers in the service of the other objectives. And so I would disagree with that in that Section 4 actually replaces the competency and the gatekeeper role in the service of it actually feathers that role with the other principles, which include access to justice, public interest, promotion of justice system, rule of law.
I know that.
I think there was a question.
I'm so sorry.
Go ahead.
Do any of you believe that requirement to join the Law Society in any way goes against freedom of association?
Yes.
Yeah?
Yeah, that was the crux of our submission, was the freedom of association argument. That in addition to the freedom of religion argument that Trinity Western was advancing, there was also a very strong freedom of association case to be made. That this was effectively preventing individuals from associating around shared core commitments. And that is, I think, that showed how different people looked at this case. If you looked at this as Trinity Western being an institution that existed to exclude people they didn't agree with, right, we would call that discrimination. But there's another way of looking at it, and I think the more appropriate way of looking at it is Trinity Western doesn't exist to exclude anybody. They exist to say, for those who do believe these things and share these commitments, this is a place that they can associate. All associations inherently discriminate in the dictionary sense of the term, right? Because all associations will not be places where those who don't share the association's core commitments would not feel welcome or would not want to join. So our argument was this was a Section 2D claim, freedom of association claim, that this was a group of people that had come together to collectively achieve a goal together, an educational, vocational, professional goal, and that they had the right to do that provided they met all other criteria. So the counter-argument in Trinity Western was a religious community doesn't have a positive right. You don't have a right to go to the government and say, you must accredit us. And that's true. But they do have a right that once they do meet all the criteria that have been set, to not be disadvantaged from receiving a benefit to which they are otherwise entitled because of their religious identity or because of their exercise of freedom of association. And that is where I think they met the test and where I think the court fell short in their analysis.
I would very much agree with probably what both my colleagues' thoughts are in terms of the Supreme Court did exceed its judicial role to the extent that I believe that it did pick a side. It did pick a side on the basis that of a belief and perhaps a value system that this decision was going to be on the right side of history, and that the opposing view was on the wrong side of history. And whatever your beliefs are, it doesn't really come into the legal analysis. And I think that to the extent that there was a thumb on the scale, I would agree that the Supreme Court, it certainly didn't approach the decision in the way that I viewed it, although I generally agree with the result. And I think most people in the audience probably agree with the result. But we're talking about how that result was achieved. And I would agree that there were some liberties that were taken in order to be on one side as opposed to the other side.
So I had a question, and I'm just going to direct towards Professor Pardy. I was wondering what you made of the argument that the legal profession is such a foundational and core institution of the upholding of our society that it should be cordoned off as an area where no training or profession or body should make any sort of, should have any sort of qualifications other than the merits. That your personal identity should not be a factor in how you are selected, or your personal identity should not be a factor in how you conduct yourself on rules of professional conduct that have nothing to do with your capabilities as a lawyer, and whether there should be these little miniature, I guess, Quebecs like dotted around Canada where it's inappropriate to wear religious symbols in that profession. What do you think of that? The neutral conduit model is another.
Well, so if you're suggesting that the state in the guise of the law society should not be assessing any of those things, then I am inclined to agree. But you can also interpret your question to suggest that there's a requirement to be neutral in the sense that you can't be yourself. You can't wear religious symbols. You can't be a Christian person or a Muslim person. You can't be an advocate for this or that. That's a recipe for disaster, because you're in danger of turning the bar into civil servants. Now, lawyers are private professionals, and they serve private clients. And an independent bar is as important to the rule of law as an independent judiciary. You cannot have the government deciding that they prefer this or that or the next thing for their lawyers, including requiring them to be personality-less or have no affiliations or to have no religion. I mean, that's not the real people. And so whoever you are, my bottom line is this: the way we achieve the kind of thing that I think you're describing is you have a certain number of requirements for competence. Again, here are the things you need to know how to do, and here are the rules by which you need to comply. And if you satisfy those things, then you're in no matter who you are. We don't care who you are. If you go beyond that, now you have the state selecting that you're okay, but you're not okay. We don't like your attitude. We don't like your philosophy, but you agree with us, so you can practice. That's a recipe for disaster.
Thank you.
I would just add that, and again, I'm sort of agreeing with Bruce, although my role here is not to agree. But I'll just add this, that in terms of the law societies, because we talked about the Supreme Court taking a side, the law society also picked a side, and I'm actually quite proud of the role that I played in helping the law society pick a side. But the law society picked a side because it has a history of discrimination itself. The Law Society, and I answer to the gentleman in the back row, the Law Society is a membership, and the membership does not have a stellar history of being inclusive. In the 1950s, if you were Jewish, you could not get a job in a law firm, especially in the city of Toronto. And the result of that was that there are now, quote, Jewish law firms, end quote. And some of the largest law firms in the city of Toronto are those law firms. And they go back to a time when people would look at your name on the resume and it would be immediately put into the paper trail. That, and we have a history of Clara Brett Martin, one of the first lawyers in Ontario, who at the same time was writing deeds that excluded any Jewish person from becoming an inheritor of this property. And we have a history of discrimination against blacks. We have serious problems, and have had serious problems in the Law Society about sexism, about sexual assault, sexual harassment, all these problems that we have in terms of the Law Society's ability to deal with different people. And that has a lot to do with the way in which this case developed. The Law Society didn't want to be on that side. They wanted to be on the other side of the debate. So there was some preference. And in terms of our understanding of administrative bodies and state delegated authorities, every single one of these authorities does have this particular agenda within a historical framework. If you go to the Human Rights Tribunal, there's an agenda. It's not an impartial. It's impartial in the sense that it'll consider the facts, but it does have a specific ideological mandate in terms of what it believes its role is. And if you go to the Society of Engineers or Architects, to this day, actually they still believe that their role is to limit the number of engineers and architects. So every body of an administrative nature does have that aspect to it, and has an influence on the way in which it decides. In this case, it decided to prefer one side over another, perhaps to prefer the Section 15 people as opposed to the Section 2 people, for those reasons.
We're nearing the end of our time, so last question or comments?
Just in response to your last question, Lee, or your last comment, Lee, and I don't disagree with what you've said in terms of the historic wrongs and needing to redress them. I think, though, that we may have a blind spot in recognizing that some of these religious minorities, and evangelicals are a religious minority, they are Section 15 people too, right? They also have their religion protected under Section 15 of the Charter. And I question whether, in the interest of trying to redress historic wrongs, which we must do, are we actually repeating some of those mistakes and now stigmatizing the new religious minority?
It is entirely possible. I don't rule that out as part of the people. We're at a stage in the world, in fact, if you go to the secular debates in France, for example, in interpreting the European Charter, we're going through a period when religion is under attack. And we're also going through a period when religion is ever stronger or polarized into fundamentalism than ever before. And it's something that we all have to consider and be global citizens and trying to understand these very complicated issues. I don't think any of the comments that you've received from the panel today are black and white. They present different points of view. But you're absolutely right. There is religious intolerance, and there's a reaction to religious intolerance, and there's a reaction to religion. What's going on in Ireland right now, because of the historical abuses of the Catholic Church, is creating an anti-church backlash, and I'm sure that will be reflected in some of the legislative acts of the Irish government in the years to come. Will it overstep it in order to trample on the rights of the Catholic faith? Probably it will. Probably it will. And there will be, we have to be vigilant of making sure that if we are certain of people's concerns, that it does not trample on them. You're absolutely correct.
Well, thank you everyone for
Thanks for
coming.
coming.
Thank you.
Thanks, everybody.